Hi, everybody. Karen Tereposky here. I am a lawyer with Samphira Tumarkin in the Calgary office in Alberta, and I am here today to answer your employment law questions. And hopefully, we have some interesting ones today. We usually do. So I'll wait for some to pop up, and then we'll start having our conversation. While we're waiting for those questions, I can just, mention a couple things that have been happening in the news. We've written some blogs and published some blogs on a few things. One of them would be kind of the effect of AI and how that's causing some companies to restructure their workforce. And obviously, leading to, with that reorganization, leading to some jobs being lost. If your organization is reorganizing and you're losing your job, you should be subject to full severance, and we can look into that for you and tell you how much you're entitled to. So if you're being let go because of a reorganization due to AI or otherwise, reach out to us, and we can review your severance package and get you what you're entitled to. Okay, we have some questions, so I don't want to get behind on these. So let's get started. So one from Reddit. My employer changed my working location shortly after I was hired and said I had to go to a different city. My commute went from 5 minutes to 35 minutes. Would this be considered a constructive dismissal? So it definitely could be. A definition of constructive dismissal is a unilateral change to a material term of the employment contract. So basically, is it a material term? Probably going from a different city. That is likely something material. It goes to the root of the employment contract. You agreed to work in, whatever, Lethbridge, and now you're going to Medicine Hat or something. I mean, that's probably a pretty material term. Unilateral, it doesn't sound like you had any agreement to it, so it should qualify as constructive dismissal. I guess, the issue for you would be, what would your recourse be? Because if it was just after you started, we look at how much your remedy for that, right? Remedy for constructive dismissal is severance, and severance is dictated to a large extent by how long you've worked somewhere. So, if it's right after you started, if you claim a constructive dismissal, you're looking at trying to get severance. And if you just started, that severance entitlement may not be very much. So, you're going to have to take a hard look at that and see whether that's a worthwhile fight to take on. Or if it's a situation where, yes, it may be a constructive dismissal, but you may want to consider, finding something else or working in this role until you do. But, really, there's a lot of factors that go into how much your severance should be. What you can do is you can use our pocket employment lawyer, which is like a calculator to kind of figure out what your severance entitlement would be. And I would say that there have been some recent cases where very, very short service employees have had an entitlement to, reasonably significant severance. So take a look at that pocket employment lawyer, and that should frame your decision as to whether it's something you'd want to pursue. Okay, that's the same question, but from different source. So let's go to the next one. This one from YouTube, from Elaine. What's the difference between wrongful dismissal, forced resignation, and other lingo used for termination? Well, wrongful dismissal is termination of the employment contract without proper notice. That's the definition of wrongful dismissal. So basically, what makes something a wrongful dismissal is the failure of the employer to give proper notice of a termination. Notice goes to how much severance you should receive, right? Proper notice, say proper notice should have been a year, you'd be entitled to a year's severance. Forced resignation, ultimately, if you're being forced to resign, you really can't be forced to resign, honestly, because a resignation needs to be voluntary and it needs to be unequivocal. So, if an employer says to you, well, you have to resign, really you're being dismissed. I would say that that's not really a true resignation. It would really be a termination of employment. I think forced resignation is a term that sometimes gets used by I believe EI. So that might be, where you're finding that word. And it's more of an entitlement to benefits on their end, is the reason that they, use that kind of language. But honestly, resignation in my mind isn't a thing, because you can't be forced to resign. It has to be voluntary. So I think likely that's something that EI uses. I believe it's EI to look at whether or not you have entitlement to benefits. So I don't know if I answered that, but hopefully that's somewhat helpful. Question from YouTube. That's the same question again. I'm getting them on two platforms. James, I was working under a 6-month contract and they terminated me with only a month left, effective immediately. Is this allowed? Well, if your contract specifically said that it was supposed to be for 6 months and they terminated you prior to that contract expiring, you could be entitled to be paid out for the balance of the contract if it's a true fixed term arrangement. Also, I guess, that would depend on what the contract says about how they can terminate it. Some contracts have language that says, they can terminate immediately for this reason, or both parties can terminate immediately for this reason. But if it doesn't have a clause like that, that allows the employer, the contract to do that, then it's possible that you could be entitled to the balance of that contract. I would recommend getting somebody to look at it, getting a lawyer to review and see if you're entitled to that last month of compensation. Because if it is a true fixed term arrangement and there's no clause in there that says they can terminate, then you may be entitled to that one extra month. Another question from Facebook. I was hired as a summer student and had every intention of returning to school in September, but my bank denied financial support, so I had to withdraw from my program. I informed HR right away and reviewed my contract, which only states I must notify them of changes to my student status. There's no mention of having to repay my wages. I'm wondering if they can legally ask me to pay back the money I earned, or if this falls into a gray area. I would say that if it doesn't have any term, and I was just looking at your question again to see what you had said about repayment of wages in your contract. Unless it says that, if you're not a student anymore, you'd have to repay your wages, then I would be super surprised if they could enforce that against you. I mean, you've done the work and they've paid you for the work that you've done. Whether or not you're returning to school shouldn't be relevant as to whether you should be paid for the work that you've already performed. So that seems to me that even if that term was in the contract, that would be something I would look to say is not enforceable. I do know sometimes with training arrangements, there can be a requirement to stay on for a certain amount of time. And if you leave early, they say you have to repay training costs. But if you've earned wages, really under employment standards, I don't see how they could possibly say that you'd have to repay those. So based on what you're saying in your question, I really don't think that that's something to worry about. Again, it would be good to review your contract and to get a little bit more detail, but based on what you're telling me, I can't imagine how you would ever have to repay wages for work that you've already performed. You're entitled to be paid for work you've performed. So another question, I'm planning to start my own business, but I'm currently employed in a similar industry. I do have a non-compete. How limiting can that be for me? Do I have to move far away to start my own company? So people get confused between the difference between non-compete clauses and non-solicitation clauses. A lot of time, non-compete clauses are not enforceable because they have to be drafted very, very particularly, and they're very difficult to enforce. A non-solicitation clause is something else. Non-solicitation means that you're not entitled to actually solicit your prior employer's clients. So non-compete actually restricts you from working in the same industry, and generally that's considered to be a restraint of trade, and they're generally considered to be unenforceable except for in very specific situations. I don't know a lot of details about your situation, so maybe yours is a situation where it could be enforced, but in general, non-competes are not something that an employer can do much with. As I said, a non-solicit, yes, they are, but there are very specific requirements as to whether those are enforceable. They have to be reasonable to protect the prior employer's business interests. And if they're determined not to be, a court would likely not enforce it. What I would caution you about is, if you get to the point where you're trying to argue before a court as to whether that clause is enforceable or not, the damage has probably already been done. So, I would get somebody to look at it and maybe enter into some negotiations with your employer as to what they will try to enforce against if you do, take those steps. It can be, I've negotiated with employers to provide exemption letters for certain activities, or to even just say, we're not going to enforce this clause. We're not going to try to enforce it. You don't want to get yourself into a situation where, you look at it and go, this isn't enforceable. And then you go out and try to do something, and then you're slapped with an injunction application, because that's, going to take a lot of money and time to respond to, and it's probably going to ruin the business that you're trying to set up. So I would get some legal advice on that. I'd get someone to review it and, give you some guidance as to what to do next in relation to your specific situation, because, all I can say is very general things in relation to, your short message to me. Okay, next question. I have generalized anxiety and had a severe panic attack at work after repeatedly asking management for support. During the incident, I followed the protocol I was given, stepping away when overwhelmed, but was pressured to return to work or to go home, and was later removed from the schedule. I've since lost 2 weeks of shifts with no formal leave or termination, and my manager is now refusing to schedule me until I come in for a meeting. Is this legal or considered discrimination, and would I qualify for EI or human rights complaint? Does sound like a human rights violation. If you have generalized anxiety and you have a diagnosis, that is a protected ground under human rights legislation, and that's a disability. So if you require accommodation, an employer is required to accommodate you to the point of undue hardship. Now, what the employer might try to say is that, it's creating an undue hardship by having to try to accommodate you. However, it doesn't sound like they've really tried to accommodate you, and they have an obligation to take steps to try to accommodate. And that includes discussing with you what sort of accommodation you require, reviewing medical information, getting, restrictions from your doctor as to what you're supposed to do or what you can or cannot do. And there's lots of things that can be done in terms of medical accommodation. Basically, do you qualify for EI? I mean, EI, you'd have to, I'm not sure if you have enough insurable hours. I'm not sure how EI would look at it. It doesn't hurt to apply. They may say this is a constructive dismissal if you're not being scheduled, as though you haven't been terminated. But, and that's the other option. You could argue it's a constructive dismissal and look at trying to get severance. Human rights, though, is likely the better route, depending on how long you've been there, how much severance you could be owed, because human rights damages are different than what severance for wrongful dismissal is. You might want to take a look again at our pocket employment lawyer to determine sort of how much severance you might be entitled to. That asks you for some factors such as age, level of position, and years of employment, and it'll tell you kind of what your entitlement might be. Human rights damages are different. They don't depend on those factors. They're often more about putting you back into the position you would have been in had the discrimination not occurred. So it can be different, and it can not depend on those kinds of things. Definitely, though, does sound like a failure to accommodate and sounds like discrimination under the Human Rights Act. So you can look on the Human Rights website for some information on what to do to make a human rights complaint. You can reach out to one of our lawyers. We do a lot of human rights complaints and assist employees with making those, and can help you out with filing the complaint and with attending at any of the procedures or that human rights sets up. So a few options on that, but I would definitely look into something there, because that does sound like you're being discriminated against on the basis of disability. Next question from YouTube. My wife's boss has been making a lot of negative comments about her upcoming maternity leave. She's worried she won't have a job to return to. What can she do to protect herself? Well, she's already protected by the Employment Standards Code. So under the Employment Standards Code, she has to be returned to the same or similar job when she returns from leave. So there are provisions in the Employment Standards Code about leave, and it would be a violation of employment standards to either terminate her employment while she's on a maternity leave or to not bring her back once she's done. That said, obviously employers violate the employment standards code all the time. If they didn't, I wouldn't have a job. So, I mean, to protect yourself from not having a job, I mean, you cannot control what the employer is going to do, but you are protected under the law. If the employer does fire her or not bring her back, she can make an employment standards complaint. She can make a human rights complaint. She can sue for wrongful dismissal. There's lots of options. So, if that would happen, it's a good idea to reach out, and you can reach out to us and we can talk about your options and what we can do for you at Centre to Markin. But yes, you are protected in that situation. So, I would say the only thing you maybe could do to help yourself out is, as we always say, document everything. What are these comments that he's making or the boss is making? When are they being made? What are they? What's the date? What's the time? What's the location? Keep track of them because you might need those later. Next questions from YouTube. May I ask, if I submit a narrative to your firm based on the details in there, can I get contingency pricing if your firm sees the case as worth it? Yes, although normally how we would evaluate your matter would be through a initial consultation. So it's usually a 30-minute phone call. What happens is you should reach out to our firm. You'll get our intake team. They'll ask for some information and they'll evaluate your claim to see if you qualify for either a free consultation or a paid consultation in some cases. And at that point, you would get a time set up to meet with a lawyer, and that would be a 30-minute or 60-minute conversation on the phone. And over that time period, a lawyer would evaluate your case and decide whether or not that's something that we can proceed with on a contingency retainer. So that's kind of the process. You don't necessarily have to submit a whole narrative. Usually when we're bringing in people for those initial consults, we ask for particular information, particular documents. Some people write, the story kind of, which is helpful, but we also, have those conversations. So that's how the process works. So, start there and start by contacting the firm, and we'll go from there. Another question from Reddit. I called in sick for 2 days with a doctor's note. When I returned, I was told I'm being let go for unreliability. Can they fire me for being sick? So under employment standards, you do have job protected leave for up to 16 weeks with a medical note. The medical note has to say that you're unable to work for medical reasons and has to say your expected date of return. So there is an employment standards violation there likely if being sick has something to do with an actual disability. So there's a little bit of a difference between being just sick, with the flu or a cold, and having a disability. Disability sometimes, like a cancer diagnosis or, some, like a anemia or something that is an actual long-term, condition that would qualify as a disability. There could also be human rights issues involved if you're being fired because you're unreliable and it's related to disability. But, first and foremost, there is a leave under employment there's a protected leave under employment standards. I would take a look at that online. You can look it up on Alberta employment standards, protected leave for, medical, basically. Sick, I think it's called sickness or illness and disability leave or something like that. But it's job protected for 16 weeks if you have medical evidence. So take a look at that or reach out to one of us at the firm and we can try to help you out with that. I have somebody saying, what state are you in? And then saying, oh, Canada, okay. Canada's a country. I'm in Alberta. Alberta's a province, which is equivalent to a state in the United States. But yeah, Alberta, Canada. Okay, so next one. My employer's given me a notice of layoff and told me that if I want to continue to receive my benefits, then I have to sign their agreement for the layoff. Should I sign? Okay. What I'm imagining is occurring here is that under employment standards, there is a way to lay off an employee. There's a procedure. And what an employer can do is they can extend the amount of time that a layoff will last under the employment standards code by providing you with a benefit. Usually that's what they do is they keep your benefits in place. I'm not sure what kind of thing you would have to sign exactly. I guess, that just saying that you agree with having your benefits extended. I've not seen them really have to be signed. Usually what happens is just a letter that says you're being laid off. We're going to extend your benefits through this time. And then when they do that, they can extend the time period, which I think is 60 days before it's a deemed termination, if you're not recalled, or maybe it's 90 days. They can extend it, I think, up to 120 days being on a layoff, as long as you're provided with benefits during that time. So, I mean, I don't necessarily think they have to get you to sign. So, signing probably doesn't help you or hurt you really. Again, I'm basing this off a one sentence text. So it would be better if I could look at what they're trying to get you to sign. But if I am interpreting what you have got from your employer correctly based on what you're telling me, I don't see an issue with it. How long? And then the same person saying, how long are they allowed to keep us on a layoff for? I am really terrible at remembering these specific numbers. I usually have to look them up. Like I had said, I think it's 60 days or 90 days. I'd have to look at the Employment Standards Code. Those kinds of things, just Google Employment Standards layoff, Employment Standards Code Alberta layoff, and it'll tell you, it comes up really quick. But yeah, I believe it's 60 days or 90 days. And then if they do provide you with benefits, they can extend it, I believe, up to 120 days. Okay. Okay, I have a follow-up one, but I don't know which comment that's with. Oh, he's told her she probably won't progress in her career, may not have a job. That must be the person who was getting negative comments from their boss with regard to their maternity leave. Yeah, write those down. Write those down. When were they said? Who said them, where, why, what happened? Because later on, if you want to make a human rights complaint because you aren't returned to work, then you have that evidence that shows that this is why you weren't returned. It had to do with your maternity leave. Another question from Facebook. My employer told me I'm being terminated with cause because of one mistake I made. I wasn't warned or disciplined before. Is that actually just cause? So one incident can be just cause, but it's not usually, like really almost never. It has to be a really serious incident, like a violent incident or, something like that, that's very, very incompatible with the continuation of the employment relationship. But if it's just a mistake, like a performance error, not having been disciplined or warned, that's going to be super hard for your employer to justify that as a just cause termination. If you take a look on our Pocket Employment Lawyer and you find that you have a significant severance entitlement for being terminated, I would say reach out to one of us at Samfiru Tumarkin, and we can take a look at your case and see what we can do with it. If you're a really short service employee or something like that, and your entitlement might not be as much, it might be better to just go to Employment Standards and make an Employment Standards complaint that just with the just cause piece, and Employment Standards will determine whether or not that is actually a just cause termination. Generally, Employment Standards will require that there's some kind of progressive discipline if it has to do with performance. So assuming that your mistake is a performance concern, the short answer is no, that's not going to be just cause, and you should fight it. Okay, we're almost running out of time here. Maybe one or two more questions. I have one up here from YouTube. I don't actually have an employment contract. Is this a problem? Should I be worried that my duties and position are properly confirmed with my employer? I don't think that's a follow-up question. I think that's a new one. So a lot of people don't have actual written employment contracts. They just have verbal employment contracts. So, I mean, I don't think it's that big of an issue that your duties and position aren't properly confirmed. Some people don't have job descriptions. If you want to, have that put together, you could ask your employer. You could sit down and try to do a position description. But yeah, it's basically, it's definitely not unusual for people to not have written employment contracts or position descriptions. A lot of employees work based on a verbal contract. So it's not unusual, I guess, is the bottom line there. We have also a question from YouTube. I was working remotely full time, but now they're demanding a return to the office or resign. Nothing in my contract mentions location. Can they force this? So, it kind of depends how long you were working remotely full time, or whether you were working remotely full time at the beginning of your employment relationship and always have, because if that has become an actual term of your employment, if that's the basis on which you're started, or if that's how your employment relationship has been for quite a while, it's likely that that could be a term of your contract, whether or not there's a written contract or not. So this kind of goes back to the last question. If that's the case, if that has become an actual term of your employment, then they can't just say to you, you're coming back right now, or you have to resign. It would be a constructive dismissal. They basically would be changing unilaterally changing a material term of your job. So that might be a constructive dismissal. Saying that you have to do it or you resign might mean that you're entitled to severance for constructive dismissal. There are some ways that employers can change terms of contract, whether material or not, and it doesn't equal a constructive dismissal, but it usually involves it being by agreement with, you being provided with a benefit and then you signing off and saying, yeah, I'm okay with this change, or by them giving you a bunch of notice saying, well, in 6 months, this is going to change, or in a year, this is going to change. So if they're doing it right now, and they're saying either return or resign, then that's likely a constructive dismissal. It's likely a material term of your employment, and likely you're entitled to severance. You could take the position that you've been constructively dismissed if that change is occurring. So there are some nuances to that. I would say, reach out to a lawyer, one of our lawyers at our firm, and discuss that, and we can see if we can help you. Okay, just some follow-up stuff. So this is from the person who asked about the employment contract. How do things like positions or responsibilities get verified if there are problems with the employer? What's to stop them from saying you had a completely different job? I mean, I guess in theory that would happen or could happen, but I mean, usually what happens is people know what they've been doing, and it would be pretty difficult for an employer to say you were doing something completely different. I don't know how they would do that, I guess. And an employer is allowed to change your job responsibilities to a certain extent. You know, People are always concerned, I guess. I get a lot of times people concerned about things being in writing. If we go through the legal process, a lot of times you don't need a document to prove something. There is such a thing as, a court listening to what you're saying, verbally, right? Here's what I did every day. And then the employer taking the position, well, no, this person did this and that and didn't do what they're saying. Likely there's going to be other witnesses that saw what you're doing. I don't know where, I guess, what you're trying to accomplish with saying that, you would be doing a different job, or what they would be trying to accomplish there. Like I said, if you're concerned about it, I would sit down with your employer and try to hash out a job description. But, I've not seen it be a problem, I guess. I wouldn't be too concerned about it. Okay, well, we're kind of running to the end of time, but I have one more question, and we'll try to do that. During my short-term disability, when I asked questions to clarify the content of my PIP, my employer refused, saying the insurance company does not allow me to engage in work-related activities. Is this reasonable? I was only asking questions for clarification, not performing any work. Is my employer's response compliant? Yeah, I mean, employers aren't really supposed to be contacting or communicating with you about work-related matters when you're on disability leave. So they likely just don't want to get into trouble, because, what I've argued sometimes is when an employee is on leave and the employers talking to them about their responsibilities or their performance, is that they're making that medical issue worse, because they're, filling their time with, these conversations about work when they're supposed to not be working. So, I would say that the employer is probably following legal advice. You can ask those questions when you return. I think they probably are acting on advice. So I think I don't have a problem with what they're doing, I guess, at the end of the day. So, 1:31, we might have got started a little bit late, but I think we've filled our 30 minutes. And thanks everybody for their questions. Hopefully I've answered everything and, given you something to think about, or, some additional ideas for resources and what you can look at, how to deal with your issue. Please reach out again, or reach out to us if you have any further questions, and also, join us for our next employment law Q&A, which is tomorrow, 1 p.m. Eastern time, with our founding partner, Lior Samfiru. Thanks, everyone, and I hope to see you again next month when I'm back.